Chapter 19, Secured Transactions in Bankruptcy, Part 1, presented by Kelly Herzick. I have broken up Chapter 19 into two parts. The first part is Secured Transactions, and Part 2 is Bankruptcy. This chapter is very in-depth and has a lot of concepts, so it made sense to break the two topics up, one part secured transaction and one part bankruptcy, because each of those topics could have easily been a chapter in your textbook. On Part 1, Secured Transactions, we will discuss secured transactions and their key definitions, the creation of a security interest, what perfected security interests are, the scope of a security interest, priority disputes between security interest levels, and default. The first topic we're going to cover are key definitions related to secured transactions. A secured transaction is a transaction in which the payment of a debt is guaranteed by personal property the debtor owns. For example, if you buy a car on credit, the lender will usually take a security interest in the vehicle. Article 9 of the UCC generally governs security interests in personal property like a car or fixtures like business equipment, but not real estate. If you buy a house, the lender will take a security interest in the house. That's your mortgage. But that is a security interest in land and is generally not covered by Article 9 of the UCC. Article 9 has been adopted by all the states with some variations. Article 9 is probably the most consistent article throughout the states under the UCC. A secured interest is an interest in personal property or fixtures that secures payment or performance of the contract to the creditor. A secured party is the person or party that holds the interest in the secured property. This is also known as a secured creditor, and you will see throughout the lesson that I tend to use the words secured creditor. A debtor is the person or party that has the obligation to pay the secured creditor. They're the borrower, and the secured creditor is the lender. A security agreement is an agreement in which the debtor gives a secured interest to a secured creditor in the collateral of the loan. Collateral is the personal property that is the subject of the security agreement, such as a car. Collateral could include goods, consumer goods, farm products, inventory and equipment, indispensable paper, which are negotiable instruments, documents of title and chattel paper, and intangibles, accounts, goodwill, and literary rights, and proceeds. For example, suppose you want to buy a new car. You do not have the entire purchase price, so you put some money down and finance the rest with your bank. You sign a financing agreement which includes a security agreement with the bank. Under the security agreement, you are the debtor giving a security interest in the car as collateral to the bank as the secured creditor. That's basically how a security interest is created. Now let's discuss the creation of security interests in a bit more detail. To become a secured creditor, the creditor or lender must gain a security interest in the debtor's collateral. Now there are three criteria for creating a security interest under UCC Section 9-203B. First, the two parties can create a security agreement in either of two ways. Either there is a record of the security interest, which is usually an agreement in writing describing the collateral and signed by the debtor, or the secured party, the lender, is in possession of the collateral. So there's either a written agreement or the creditor actually holds possession of the collateral. That's the first section. The second thing that they must do is that the secured creditor must give value to get the security agreement. And finally, the debtor has a right in or to the collateral. Once these three criteria are met, the security interest attaches to the collateral. Once attachment occurs, the creditor becomes a secured creditor with interest in the collateral. Now, attachment is the point at which a creditor becomes secured, meaning the creditor has a security interest in the collateral. There's nothing magic about that. Now we will discuss the three criteria for the creation of a security interest in a bit more detail. As I stated on the first slide, the first criteria for creating a security interest is that the parties create a security agreement and either the party's agreement is in writing or the creditor takes possession of the collateral while the debtor pays on the loan. Now, holding the collateral is pretty straightforward, but there are some specific requirements for a written agreement. The written agreement is usually called the security agreement and must be signed by or authenticated by the debtor. The UCC uses the word authenticated for the debtor's signature to account for electronic filing. In reality, in this section, there is no actual requirement that the debtor's signature be a wet ink signature. The security interest must describe the collateral, and it must be both accurate and detailed enough to specifically identify the collateral. For example, if you buy a car on credit, the security interest may say white Toyota Camry, but it will also include the car's VIN number, VIN number, to specifically identify the car. If the description were only white Camry, that would be too vague as there are probably millions of that car on the road. There would be no way to determine which of the millions of white Camrys security interest is actually in. If the collateral description is not sufficient to identify the collateral, like white Camry, the secured creditor can lose its rights in the collateral and become unsecured. Now, the next criteria for a security interest creation concerns value. And that's straightforward. The creditor must give value, which is consideration, which is usually money or a loan. The last criteria concerns the debtor's rights in the collateral. So the last element of a security interest is that the debtor must have rights to or in the collateral. For example, once a debtor signs a purchase agreement for a new car, the debtor has a legal right to the vehicle and can use it for collateral or insure it. So as soon as they sign on the dotted line, technically the car is theirs and they can use it as collateral for a security agreement. On this slide, we'll discuss purchase money security interests. A purchase money security interest is a specific type of security interest under the UCC. A purchase money security interest is a specific type of security instrument which is formed when a debtor uses borrowed money from a creditor to purchase the collateral which becomes the subject of the security instrument. Under the UCC, a purchase money security interest is created when a security interest is taken by the seller of the collateral to secure all or part of the purchase price, or by a person who gives something of value to the debtor, such as a loan, so that the debtor can gain rights to or use the collateral. For example, if you get a loan to buy a car from the dealership will take a purchase money security interest in the vehicle. Or if you go to a third-party lender like the bank, and the bank lends you money to buy the car, and you use the money to buy the car, the bank will also receive a purchase money security interest in the car. Next, we will discuss the importance of a perfected security interest. Now, default occurs when a debtor fails to make payments on a loan. If a debtor defaults on a loan held by a secured creditor, the creditor can ultimately repossess the collateral and sell it to recoup the amount owed by the debtor. If there are competing security interests in the same collateral, the secured creditor who perfects his or her security interest first in time has priority, has first claim, meaning they are first in line to repossess and be paid on their lien. So if you are first in time, you are the first creditor, generally. There are some exceptions and we'll talk about those. I call it being the first pig to the trough who gets to eat. Perfection of a security interest involves a series of legal steps a secured creditor takes to protect its rights in the collateral from other creditors who want their debt paid through the same collateral. Perfection of a security interest can occur in a variety of ways, but the most common way perfection occurs is by filing what they call a financing statement, a UCC-1 form, with the designated state agency for filing. In Kansas, most financing statements are filed with the Secretary of State and can be done electronically, online. So as you can see, there would be no reason for the debtor's signature, for example, to be a wet ink signature if you can do it online. Next, we will discuss perfecting a security interest by filing. A financing statement is a written document that lists the names and addresses of the parties, which are usually the debtor and the creditor, to the transaction. and it also specifically describes the collateral to the transaction. That's UCC 9-502. Now your book says it's required to be signed by the debtor. That's not really true. 9502 doesn't actually require a signature. It can include the debtor's signature, but it doesn't actually have to. The financing statement must be filed with the correct state agency and under the correct name of the debtor, no matter if the debtor is an individual, a corporation, or other business form. You have to get the name right. That's key. Most states, including Kansas, allow for electronic filing, but also have paper filing. It takes a lot longer for it to be registered. It can be up to 30 days if you send in the paper. Getting the electronic filing done, it's usually attaches almost immediately when you file it. If the filing is under an incorrect name, the perfection is usually not effective. You have to get the name right. If the financing statement does not correctly or specifically identify the collateral, remember that's the white Toyota problem, the statement will not give notice to third parties that the collateral is impaired, which means burdened with a lien. If the statement does not correctly identify the collateral, it's likely ineffective and you wasted your time filing it. Now, it's possible to use the description of the collateral from the security interest, but that makes it all the more important that the collateral description used from the beginning of the transaction must give notice to a third party that the secured creditor has a first lien on that specific collateral. So you have to make sure that the description of the collateral is good from the beginning if you're just going to cut and paste it, which a lot of creditors do. Once the financing statement is filed with the state, it becomes public knowledge. A UCC Form -1 is the standard form for financing statements generally used by lenders in the United States. And that's because most states will not accept the lender's own form. They require a UCC-1 form or they won't allow you to file it. If the debtor is an individual, the secured creditor files the financing statement in the state where the debtor resides, sometimes with the Secretary of State, like in Kansas, and sometimes in the county where the debtor lives, depending on state law. So you have to make sure before you file your financing statement that you check state law to find out where you're supposed to file it, because if you file it in the wrong place, it's ineffective and you have no security interest. If the debtor is a business, for most kinds of business organizations, a creditor needs to file the financing statement in the state of incorporation or organization. Though if an entity does business in multiple states, it can be filed in each state where the company does business or in the state where the chief executive office is located. In Kansas, you're lucky because if the debtor is a registered organization, the financing statement must provide the name of the debtor exactly as it is on file with the Kansas Secretary of State's office. But they have a database. You can search the Kansas Secretary of State's database for exact names. The financial statement filing is divided between individual debtor, registered organizations, and unregistered organizations in Kansas, and you can search each of the databases to make sure the name is correct. For certain types of collateral, as extracted collateral, timber to be cut, fixture filings, and goods to become fixtures, generally the appropriate filing office is where the collateral is located. In Kansas, these are filed with the Register of Deeds. So these are an exception to filing with the Secretary of State in Kansas, and they're very specific. Because there is a database of these filings in every state, it is commercially reasonable for lenders, prior to lending money, to search these databases to make sure there are no other liens on the collateral. Otherwise, a lender risks becoming a junior or secondary lien on the same collateral, which in most instances dramatically reduces the likelihood of recovery in the event of default and could render the second lender an unsecured creditor. Under the UCC, a properly filed financing statement is valid for 5 years. After the 5 years expires, the security interest is no longer valid. However, within 6 months, the secured creditor can file a continuation statement that will extend the financing statement for another 5 years if the term of the loan is still ongoing. If the loan is paid off, the secured creditor is required to file a termination statement within 30 days, which amends the UCC-1 and states the debtor has no further obligation to the secured party. So now that we've discussed perfection by filing, let's go through an example. A Kansas business owner, ABC Painting Inc., borrows money from Big Bank and uses the business's equipment as collateral for the loan. The bank, as a secured creditor, files an electronic UCC-1 financing statement with the Kansas Secretary of State's office, specifically giving ABC Painting Inc.'s legal name per the Kansas Secretary of State, its own name, and a specific description of the equipment as collateral. By filing a financing statement, the bank establishes its priority in the event ABC Painting borrows the money from others, files for bankruptcy, or becomes insolvent. This filing gives notice via public record to other lenders that the secured party, Big Bank, has a first lien security interest in the business equipment of ABC Painting. Next, we will discuss perfecting in a security lien by possession of the collateral. A debtor can give a creditor the collateral to hold while the loan is being paid off. For most businesses, giving the collateral to the creditor is not practical, as the collateral is usually needed to run the business. The transfer of collateral to the secured creditor for the purpose of perfecting the lien is called a pledge. Once a secured creditor takes possession of the collateral, it has perfected its security interest. The secured creditor does not have to file a financing statement with the state. Perfection by possession only requires taking possession of the collateral. In this instance, there does not need to be a written security agreement either. This is an exception to the general rule that there must be a writing. Now, certain types of collateral require perfection by possession, mainly instruments, documents that serve as evidence of the right to payment of money, such as certificates of deposits, checks, and stocks and bonds. Now, a security interest in a promissory note may be perfected either by filing a UCC-1 or taking possession of the note itself. Once the loan is repaid, the collateral is returned to the debtor. In addition to filing a UCC-1 form with the state or taking collateral, there are other ways to perfect security interests. The first is automatic perfection. With consumer goods like appliances or household furnishings, TVs, it's not practical to require the filing of a financing statement. When a creditor sells a consumer good to a debtor on credit, or when a creditor extends a loan to purchase a consumer good, a security interest in the good is created and perfected automatically at the time the product is bought and the loan extended. A consumer good is one that's bought primarily for personal, family, or household purposes. So if you buy a TV on credit, a security interest in the good is created and perfected automatically at the time you buy it and you get the loan. Then there's perfection of movable collateral. Under the UCC, a security interest perfected in one state will generally transfer to another state for 4 months from the date the collateral is brought into the new state. The secured party must file a new financing statement in the new state, or it may lose its perfected status and lien priority. Then there's perfection of security interests in autos and boats. To perfect a security interest in motor vehicles, a notation of the security interest will need to be noted on the title to the vehicle. It has to be there. You can look at Exhibit 19-1 on page 399 of your textbook for a good summary of perfection methods. Next, we will discuss the scope of a security interest. Generally, once a security interest is perfected, the perfection is effective until the collateral is sold, exchanged, or transferred, or until the time expires. So far, we've been reviewing perfection of security interests in goods the debtor currently possesses. However, a security interest can also attach to property not yet in the debtor's possession. The first way that can happen is after acquired property. A creditor can take a security interest in after acquired property. This is property that is obtained by the debtor after the security agreement is made. After acquired property can be inventory, livestock, equipment, or almost any other type of property generally that moves in and out of a debtor's business. For a security interest to attach to after acquired property, there must be a provision in the security agreement allowing the creditor to take this type of security interest, and it must identify the type of property to which the security interest will attach. It has to be as specific as possible, and the debtor has to agree to it in writing. When the debtor buys new goods such as inventory, if there's an agreement to attach to after acquired property, the existing security interest attaches to those new goods once the debtor takes possession of them. Then there are proceeds. When inventory or goods are sold, the resulting cash is called proceeds of the sale. A secured creditor has an automatic interest in proceeds from secured collateral as long as the proceeds are identifiable cash. Otherwise, like if there is an exchange in kind, the interest remains for 20 days after the collateral is sold, after which the creditor has to file a new UCC1. So if they don't get cash, if they get other goods in exchange, a new UCC1 is going to be required. Now, the reason a secured creditor gets an automatic interest in proceeds of collateral sales is straightforward. If the collateral is sold, then the creditor has less secured property to rely on in the event of a default. Next, we're going to discuss lien priority disputes. The purpose of filing a financing statement, in addition to perfecting the security interest in the collateral, is to give notice to third parties of the creditor's lien and to preserve its priority in the collateral in the event of a default. Sometimes there are competing liens by creditors to the same collateral, and this can lead to lien disputes. This most often occurs when the debtor stops paying or files for bankruptcy. The first category are secured versus unsecured creditors. Generally, a secured creditor has priority over an unsecured creditor. 99.9% of the time, the secured creditor is always going to win out over an unsecured creditor. A secured creditor has an attached security interest in the collateral, while an unsecured creditor, though it lent money on the same collateral, does not have a security interest in the collateral at all. It will be the secured creditor that can generally repossess the collateral over the unsecured creditor. And 9 times out of 10, the secured creditor, once the collateral is repossessed and sold, is the only one who gets paid. And the secured creditor gets all the money and the unsecured creditor gets nothing. Then there are secured versus secured creditors. If both parties are secured creditors, the one with first priority will be the one who perfects his security interest first in time. That's a race to the courthouse, or should I say a race to the Secretary of State's office. If neither secured party has a perfected security interest, but they both have a security interest, the one with the first in time security interest has first priority to the collateral. Again, if you are first in time, you are first in the lunch line to get paid. You can look at Exhibit 19-2, which has a brief but good summary of priority of creditors' claims to collateral and which creditor generally prevails. Next, we're going to return to purchase money security interests. These have special rules and generally have some additional protections under the UCC. In purchase money security conflicts, generally a perfected purchase money security interest prevails over, has priority over, other claims to the collateral. The rules regarding purchase money security interest generally depend on whether the collateral is inventory or not. If the purchase money security interest is in inventory, the perfected purchase money security interest has priority over a previously perfected non-purchase money security interest if the purchase money security interest creditor perfects its interest before or at the same time that the debtor receives or takes possession of the inventory, and the purchase money security interest creditor checks for previous security interests of the holders of non-purchase money security interests. That means they go and look up in the databases of the state to see if there are any previously recorded non-purchase money security interests in the same inventory. If the purchase money security interest is not in inventory, the purchase money security interest has priority over any other secured perfected interests as long as the purchase money security interest is perfected within 20 days of the debtor's possession of the collateral. There are other types of priority disputes. These can arise between secured parties and third-party buyers who have possession of collateral. If a debtor sells collateral in which a creditor has a security interest, the security interest generally remains in effect, meaning it travels with the collateral. And if the debtor defaults, the creditor can repossess the collateral even from a third-party buyer. That's the general rule. For example, Larry buys a laptop from Best Buy and finances the purchase with Best Buy. If Larry then sells the laptop to Bob, the security interest that was automatically created in favor of Best Buy is still effective. It travels with the laptop. If Larry then defaults on his loan to Best Buy could repossess the laptop even though it's in Bob's possession. Now that's the general rule, but there are exceptions, because there are always exceptions. Buyers in the ordinary course of business. This is a person who routinely buys goods in good faith from a person who routinely sells such goods. Under the UCC, a buyer in the ordinary course can take goods free and clear of any lien, even if the security interest is perfected. Then there are buyers of consumer goods. Remember that a purchase money security interest in consumer goods perfects automatically. If a consumer good is resold, as long as the second buyer is not aware of the security interest and purchases the goods for personal use and buys the consumer good before the secured party files a financing statement, the buyer gets the consumer good free of any security interest. Now, even though purchase money security interests in consumer goods perfect automatically at the time of the loan and sale, in order to prevail against a third-party buyer who buys a consumer good for personal use, the creditor still has to file a financing statement to win. In real life, that doesn't often happen. So in our example between Larry and Bob, if Bob buys the laptop from Larry for personal use and Best Buy hasn't filed a financing statement over the laptop, then Bob's going to win and Best Buy won't be able to repossess that good. That's an exception to the general rule. Then there are buyers of chattel paper and instruments. If a buyer buys these types of collateral in the ordinary course of business, the buyer acquires them free of any security interest as long as the buyer is unaware of the security interest. The next topic we're going to cover is default. Generally, when a debtor fails to make payments on a loan or declares bankruptcy, the debtor is in default on the loan. Default is not defined under the UCC, oddly enough. Default and the consequences of default are usually defined between the parties to a security agreement, though creditors often have more bargaining power and so usually set the definition of default and its consequences. If there is a default, secured creditors can usually seek to repossess the collateral or seek a judgment on the security agreement, or both, if one is not successful. In many suits to repossess the collateral, creditors often sue in the alternative on the loan as well to recover any deficiency after the sale of the collateral, as it rarely fully satisfies the debt. Now, unsecured creditors cannot repossess the collateral. They must file suit and seek a judgment in the amount of the debt. However, if a debtor has filed for bankruptcy protection, the bankruptcy code will apply and will restrict the rights of creditors to repossess collateral or sue for a money judgment. We will cover bankruptcy in the second part of this lesson. Next, we will discuss taking possession of collateral. The most common remedy for default is repossession of the collateral. If you don't pay on your car note, the company can go out and repossess your car. A creditor can take possession of the collateral without court order if the creditor does not breach the peace in repossessing the property under UCC section 9-609 subsection B. Breaching the peace is not defined by the UCC, but under the law that generally means that creditors cannot use force or commit trespass. Most commercial agreements have provisions that require the debtor to turn over the collateral to the creditor within a reasonable time and manner if they stop paying on the loan. If the debtor refuses to turn over the collateral, many times companies will hire third-party repossession companies, who are usually considered independent contractors, so if they commit torts, the original creditor isn't liable for their torts. If the creditor cannot use self-help to repossess the property, the creditor will be required to use judicial process, file a lawsuit, to force the surrender of the collateral. Once the creditor recovers the collateral, it can either retain or dispose of the collateral. The last topic we're going to cover in this half of the lesson is disposition of collateral after repossession. Under the UCC, Section 6-610, a secured party can sell, lease, or transfer the collateral in any commercially reasonable manner after repossession. Sales of the property may be a private or public sale and must seek to receive a fair market sales price for the collateral. No fire sales. The debtor and any other entities who have an interest in the collateral must be notified of the sale. Once the collateral is sold, proceeds are paid in the following order. For the reasonable expenses of retaking and disposing of the collateral, including attorney's fees, then to satisfy the debt owed to the first secured party, and finally to satisfy any junior lien holders. Instead of selling the property, the collateral can be retained by the creditor. The secured creditor can retain the collateral in full or partial satisfaction of the debt. The secured party must give notice of its intent to retain the collateral. The debtor has 20 days to object, and if it does not, the creditor can retain the collateral. But if there is a timely objection, the secured party must sell or dispose of the collateral. They don't have a choice. If the collateral is valued at or above the debt, the secured creditor takes the collateral as full satisfaction of the debt, meaning the creditor cannot sue the debtor or make any further claim on the debt. If the collateral is valued at less than the debt in a consumer transaction, the creditor cannot seek additional money from the consumer debtor. In non-consumer commercial agreements, the secured creditor can retain the collateral in partial satisfaction of the debt only if the debtor explicitly consents to the amount of partial satisfaction in an authenticated record created after the default. In the case of full satisfaction, the debtor may consent either in an authenticated record or by deemed consent if it fails to respond to the secured party's notice of the proposal to accept collateral within 20 days. This is the end of Part 1 of Chapter 19.